Do you want a minute? I mean,
I'm good.
You're all good? All right, well then we'll get started. Good evening, everyone. My name is Adam Carson. I'm the Executive Director of the Rockland Municipal Planning Federation and Associate Planner with the Rockland County Department of Planning. Welcome to session 2 of our certification series, The Update of Case Law, where we learn about recent developments in the courts and hopefully how to avoid any legal pitfalls. The primary goal of the Federation is to provide topical educational sessions to local land use board members to help them make more informed decisions regarding the development applications that come before them. The certification program began in 1993 to educate Planning and Zoning Board of Appeal members on the fundamentals of participating on a municipal land use board. The 3 certification courses are Session 1, Overview of the Boards, Session 2, Update of Case Law, and Session 3, which is broken into separate working group discussions for Planning Board and Zoning Board of Appeals members. Board members in Rockland County are required to complete all 3 courses to become certified and to take Session 2, tonight's session, every other year to be recertified. Helping us out with that tonight, we are very fortunate to have with us attorney Christy Tomadonna. But before I turn things over to Attorney Adana, I do have a few items to go over. First and foremost, I have to give a big thank you to the Cornell Cooperative Extension of Rockland County for providing technical support and hosting this Zoom session. In particular, I have to thank Suzanne Barkley, Executive Director, and Deirdre Heyman, Communications Manager. This could not have happened without their help, and I am very grateful. Second, you've probably noticed that your microphones have been muted. If you have questions, please type them into the chat function. I'll be monitoring the chat, and we will take a break to answer questions during the presentation and again at the end. Please limit your questions to the cases discussed or to general areas of law. Attorney Adana is not in a position to answer specific questions about developments in your community. And I will share my email in the chat function. I just want to let you know that if you are a land use board member in Rockland County, just stay through the session and we'll credit you with your training hours. You don't have to do anything. If you are a land use board member outside of Rockland County and would like a certificate of attendance to give to your town or village staff, please email me your information at the conclusion of the session and I will generate a certificate for you. Also, if there are any attorneys out there who would like to get CLE credit, please email me after the session. I will send you a course evaluation form and an attorney affirmation form. On this affirmation form, you'll have to enter the secret code words. What are the secret code words, you ask? Secret code words are how the New York State Continuing Legal Education Board verifies attendance at virtual events. Throughout the session, I will announce a code word. I suggest you write them down so you can provide them on your affirmation form. If you are not an attorney seeking CLE credit, you don't have to worry about it. And since we're on the topic, I will jump right in now and give the first word, which is Euclid, E-U-C-L-I-D. I believe that's a good place to start. And now allow me to introduce our speaker. Christy Tomadonna is a partner at Silverberg Zelantis LLC, where she works on litigation and appeals as well as land use applications. She advises municipal boards, including those in the towns of Haverstraw and Ossining and the village of Tarrytown, acting as lead attorney for the Ossining Town Board, the Town of Haverstraw Planning Board, and the Zoning Board of Appeals for Haverstraw, Ossining, and Tarrytown. She also counsels parties appearing before municipal land use boards. In addition, Christy has worked on a number of Article 78 proceedings, either defending or challenging administrative decisions. She further assists the firm's clients with employment law issues and commercial litigation. Christy regularly lectures on zoning and land use topics and has been acknowledged in the 2008 publication of the New York Metro Super Lawyers as a rising star in the area of land use and zoning law. Prior to joining Silverberg Zelantis LLC, Christy was employed by civil litigation law firms and worked on cases from commencement of lawsuit through trial and appeal. Christy has worked with a variety of clients, including large corporate entities, not-for-profit corporations, and individuals. Her prior experience includes insurance, defense, tort, maritime, contract, and employment law. Ms. Adana received a Bachelor of Arts with majors in economics and history from Swarthmore College and graduated magna cum laude from St. John's University School of Law. and she has been admitted to practice in New York, New Jersey, Federal District Court of New Jersey, and the Federal Southern District of New York. And with that, that's my introduction. If you're ready to take it away, Christy, go right ahead.
Thank you, Adam, and welcome to your new role with the County Planning Federation. We happy to have you, and I hope Arlene's happy wherever she is. Thank you also to Deirdre and Suzanne, as Adam mentioned, for coordinating this and putting this together. I apologize again to everyone for being a couple of minutes late. So we're just going to dive right in, just a little brief overview. What we're going to be talking about mostly tonight, which is often the case, are Article 78 proceedings, meaning that someone is challenging a determination or action by a municipal board or official. In the vast majority of cases, it's either a property owner challenging an unfavorable decision or a neighbor challenging a favorable decision to another property. And with the exception of the telecommunications case and the Arlupa case, these are all appellate cases. So they've been reviewed at the lower court level. And that we also have a large amount this time from the Second Department Appellate Division, which is the controlling intermediate appellate court in Rockland, Orange, Westchester, and neighboring Hudson Valley counties. So I did prepare a handout that I believe Adam circulated. If anyone needs it, you can always email me. There are a couple of cases that I just know I'm going to have to just read off the handout because we're going to be dealing with time constraints, as I usually do. The formatting was just a little bit, and this is kind of an overview of tonight in general, was a little bit more general in terms of topics because a lot of the cases were a lot more dense. So they had a lot more going on and a lot more issues. It wasn't just strictly an area variance here or a site plan there. So we'll be getting kind of a sprinkling of different topics throughout the talk. And so I think it's interesting to see how they come together and how they work together. But it means I'm going to have to talk really fast. So let's get started. The first case is Mueller versus Zoning Board of Appeals of the town of Lewisboro. And the first section, that we're going to be talking about is generally site plan and special permits. Special use permits, which are called compatible use permits, special exemption permits. And we'll hear a lot of that tonight because there were a lot more special use permit cases than I've really seen ever before, but in interesting context. So hopefully you think so too. So in Mueller, the petitioner was basically housing 11 Siberian Huskies on his 2-acre property, which was in a residential zoning district. So the town basically said, you basically have a dog kennel going on here. And that was a permitted special permit use in the district he was located in. And so he had to make an application to the zoning board for a special use permit. However, there were certain conditions on when that use is permissible that he did not comply with, which included the acreage. The property had to be at least 4 acres and there could be no more than 10 dogs, and he had 11. So the zoning board ultimately denied this special use permit application, and petitioner brought a proceeding pursuant to Article 78 challenging the denials, and also separately brought a declaratory judgment action claiming that the law that limited his ability to have dogs on his property was unconstitutional. So first, the court went through the standard for a special use permit and explained that this is a use that the local legislative body, in this case, the town board, has specifically added to the code, and in doing so made a determination that it is a use that's appropriate in the zoning district. And as a result, the application will be granted, assuming that the proposal complies with the conditions that are in the code. As I already mentioned, that was not the case in the Mueller case. So what do you do when you have conditions in the zoning code for a special permit use that you can't comply with? The court said you cannot just waive it. The zoning board, because it's a legislative determination by the town board, the legislative board, the zoning board does not have the discretion to just say, okay, we're not going to consider that. What it can do, as it's in its appellate jurisdiction with authority to vary the zoning code, is grant a variance subject to the area variance criteria. So that was what the applicant asked the zoning board to do in this case, to first grant a variance from those conditions that he didn't comply with, basically the lot size and the number of dogs. And then upon granting the variance, grant the special use permit. And the zoning board said no. First, they denied the variances, and we'll discuss in a little bit later the standard for a variance and what that looks like. But upon the denial of the variances, the court agreed that because the variances weren't granted, the application did not comply with the conditions for the special permit use. And the court said that failure to meet any one condition of the ordinance is a sufficient basis for the board to deny the special use permit. So what happens in that case? Well, the lower court just threw the whole thing out. And the second department, the appellate division, said, well, we agree with you to the extent that it applies to the Article 78 proceeding challenging the zoning board's actions, but you moved a little too fast with the constitutionality claim, because that's subject to a separate procedure and a separate standard. Article 78 proceedings challenging agency determinations often are handled in a summary proceeding, which is basically like a motion. So each party puts in their papers. The evidence is basically the record that was before the zoning board or the planning board or whatever agency is making the determination, and then the court rules and then it's over. But that's not the case in other types of litigation, and specifically with constitutionality claims. So the court said, hey, lower court, you got to take a closer look at this. They didn't talk about the substance of the claim, and local laws are subject to a strong presumption of constitutionality. So I'm not sure that claim was ultimately going to go anywhere, but it was a procedural distinction that the court decided to make. And so the next case is FCFC Realty LLC versus Weiss. And in this case, the petitioner made an application to the zoning board for variances and a special exception, which, as I said, is another term for a special use permit, to construct a building for a laundromat and retail space. After the public hearing, the zoning board denied all of the requested relief, which was several variances and the special use permit. And the petitioners challenged those denials in an Article 78 proceeding. As an initial matter, the petitioner raised an argument that I don't see very often. He raised a due process violation, claiming that because the zoning board relied upon written statements made by members of the public, where those members of the public were not present and petitioner did not have the opportunity to cross-examine them, that they should not have been weighed into the decision. And the court basically said, nice try, but no. The court explained that while parties, including the public, especially during the public hearing process, may have the right to appear before the board and have their voices heard and have their opinion made clear, it's not under those formal standards of being sworn in and having an opportunity for cross-examination. These are quasi-legislative, quasi-administrative boards, and the public hearings are informational in nature. So you're supposed to be gathering facts about the application in order to make a decision, not concerned about the specific. Of course, you have to follow a certain procedure, but with respect to things like cross-examination, that doesn't really come into play. And with respect to the variances, I'm not going to get into this too much because, again, we'll talk about it later. But one of the variances that the zoning board denied was for off-street parking. And what I found interesting, because we'll hear in some other cases that generally the courts are very hesitant and warn about boards making decisions based upon quote unquote generalized community opposition. In this case, the court did specifically say that it was appropriate for the zoning board to take into consideration the comments that were made by the neighbors in the area, because these were people who lived in the area and had expertise about what conditions were like in that area. So it was reasonable for the zoning board to take their opinion as to what the impacts would be from traffic and parking from that parking variance into account. The court also noted that the petitioner did not present any expert evidence to the contrary. If petitioner had put in a parking study or a traffic study, then that may have required a greater standard of review on the zoning board's end. But without that, it was reasonable for the zoning board to rely at least partially upon the input of the neighboring property owners. So with respect to the special permit application, the court did explain what the distinction is between a variance and a special permit. And I always like to bring this up because I think it's an important distinction. So the court said, unlike a variance, which gives permission to an owner to use a property in a manner that's inconsistent with a local zoning ordinance, that's a variance, a special exception gives permission to use a property in a way that is consistent with the zoning ordinance, although not necessarily allowed as of right. So you don't, with a variance, you don't have that legislative determination backing you up. So generally you do see that the standard for special permits is a little bit more lax than with a variance, which is also one of the reasons why I was surprised that there are so many cases challenging those determinations. But in this case, the court said that there was evidence in the record to support the zoning board's denial, and it was not arbitrary and capricious for the zoning board to do so, because a laundromat of the scale and magnitude of what the petitioner was proposing, with 112 dryers and 112 washers and 90 dryers, was definitively going to increase the traffic and parking issues in the neighborhood to the detriment of the neighboring property owners. And while, again, the court, especially in this case, did acknowledge that generalized community opposition is not sufficient basis, where it's based upon facts of people with knowledge of the community, and there's other facts in the record to support the denial, then the court will uphold it. So the next case is Sid Jacobson Jewish Community Center, Inc., JCC for short, versus the Zoning Board of Appeals of the Incorporated Village of Brookville. So JCC, which identified itself in the complaint as a nonprofit, non-sectarian Jewish organization, operated a day school and camp on its property that was located in a zoning district. And now, while the court doesn't expressly say this, my sense is that the use predated zoning. So it was a legal non-conforming use. So it was there before there were zoning regulations put on what could be in that location, which means it's allowed to continue, but subject to the restrictions that are in the code. And generally those restrictions include not allowing that use to be expanded or enlarged. So in this case, what JCC wanted to do was expand their property. And so they needed a basis for it to be a conforming use. Otherwise they would have been precluded from doing so. So the code created this, what I think of as a safety net type of provision, so to speak. And what it did was it created this kind of catch-all, although pretty narrow, conditional permit use of any non-residential uses which may not be excluded pursuant to state and federal laws. And I actually think that's a pretty smart thing to have in your code, because it kind of covers you in case someone says, well, you have this in your code and it precludes me from doing this, which I should be allowed to do under my constitutional rights. You could say, well, we have this special permit use. That kind of encompasses all of that. And it also provides some level of review at the administrative level for incorporating those uses. So the use, again, is a non-residential use that would not be excluded pursuant to state and federal law. So what possible uses could that be in the context of JCC? It was potentially a religious use, and it was potentially an educational use, because those are uses that under the law are entitled to deferential treatment in applying the zoning code. So the zoning board looked at this application and said, you know what? We don't think this is either. Even though JCC is a religious organization and no one was questioning that, the activities and programs that they were offering at the day school and camp were standard recreational activities offered at any summer camp. The camp was recreational, it wasn't academic in nature, it wasn't religious in nature, and the camp noted that the court noted that the camp operated under a children's camp permit, and the activities were athletic and recreational. And there was also no evidence that the staff was qualified to instruct on educational matters. So while JCC wanted to be able to use that catch-all in order to make itself a special permit use that it could avail itself of, based upon the facts of what it was actually doing on that property, the summer camp, as opposed to an actual religious and educational use, the zoning board said that we don't think it fits within that category. And the court agreed under those circumstances and thought it was appropriate to find that it was not a special permit use under the code. But the zoning board went a step further and said, you know what, even if it is a special permit use, we're still going to deny it because we think it's going to be a detriment to the neighborhood based upon the expansion of the use. And the court said that because that was based, again, upon testimony from neighbors who were familiar with the area and the zoning board's knowledge, and it wasn't based specifically, exclusively on subjective considerations such as general community opposition, that was a sufficient basis to deny it. So the zoning board initially said it wasn't a special permit use, but even if it was, we're still denying it on these grounds, and the court upheld them the entire way. So the next case is Gursha Recycling of Riverhead, Inc. versus Town of Riverhead. So the petitioners purchased a property that had been operating as a pre-existing non-conforming auto salvage facility. So again, this is another use that wouldn't normally be allowed to come into existence today, but because it had been there and because it had already been existing, it was allowed to continue operating. So petitioners purchased this property with the auto salvage use, and they submit an application to the Town Planning and Building Department, basically to do site work. They wanted to do some drainage, they wanted to regrade, retaining wall, concrete paving, landscaping, but nothing related to the structures specifically, and nothing related to the use. So the departments looked at this application and said that it was really de minimis and exempt from site plan as that was defined under the code. So the owner goes about his merry way. He comes back about a year and a half later with an as-built plan that looks very different from what the town had seen a year and a half ago. And basically, under the guise of their site work, they had changed the use of a property from a legal non-conforming auto salvage facility to a recycling center, which was just non-conforming. There's no legality to that. You can't just switch from one non-conforming use to another. Most codes preclude that. If you're going to change the use from the legal non-conforming use, you have to change it to a legal use. So this was not acceptable. So they had to go to the planning board for site plan approval. On this one, the administrative staff did not find it to be de minimis. And the planning board held a public hearing, after which point the town actually initiated a proceeding against the owner for the illegal change in use. But the planning board never actually made a determination on the site plan application. Instead, they had the planning and building commissioner, that same administrative body that had originally determined that the application was de minimis last time around, write to the petitioner and say that under the town code, he had the authority to render site plan decisions on site plan applications, and that he himself was denying the site plan application on the grounds that it was not a permitted use. And the commissioner advised the petitioner that they could appeal his determination to the zoning board as the appellate authority for an entity charged with interpreting the zoning code. Petitioner did not go to the zoning board and instead went straight to court, bringing an Article 78 proceeding to challenge the commissioner's decision, because again, the planning board had never ruled. So in this case, while the court doesn't address the merits of petitioner's use of the property, and based upon the facts, I think the petitioner would have really been hard pressed to argue that what he did was okay and without getting the necessary approvals. The court did agree with petitioner that the town's procedure was flawed. So what the court said was that the commissioner had absolutely no authority under state law or the town code to deny the amended site plan application. Under New York Town Law 274A, which is a state statute, the town board has the authority to charge the planning board or another administrative body with hearing and deciding site plan approvals. And then in the town code, where the town board implemented that authority given to them at the state level, the town board authorized the planning board and specifically said, pursuant to 274A of the town law, to review and approve with modifications, or disapprove site plans. Therefore, under the code, the commissioner did not have authority with, that's not, so the commissioner's claim wasn't completely unfounded. There were other provisions of the code that did give the commissioner some authority with respect to site plans, and specifically with respect to determining whether the site plan was in compliance with the zoning code. And so he could have said, I don't think your application is in compliance with the zoning code. What he couldn't say is your application is denied. And that's what he did. And the court said he didn't have the authority to do that. And because he didn't have the authority to do that, the petitioner was not required to exhaust its administrative remedies, which it otherwise would have had to do by going to the zoning board before going to court. So instead, after all this time and all these issues, the court sent the matter back to the planning board to make a determination on the amended site plan application, which is where petitioner had started 7.5 years earlier. So, you know, these things take a long time. You don't just walk into court and get an answer, even in an Article 78 proceeding. by the time you brief everything and then the court makes a decision. And then if you appeal, it could be years before you end up to right back where you started after losing a whole heck of a lot of money. So the next case is Grout versus Vissum Development Corp Group LLC. In February 2019, the property owner made a site plan application to the planning board to construct a 3-building apartment complex with a parking lot. The planning board issued a negative declaration pursuant to SECRA, which we'll talk about later, and then issued site plan approval on September 16th, 2019. So the application was made in February, approval in September. The dates are kind of important here. Petitioners were neighboring property owners who opposed the application. And upon the planning board granting site plan approval, they attempted to appeal that determination to the zoning board on the grounds that the application was not zoning compliant and that it required variances that the applicant had not received. However, when they tried to make that application, they were told by the zoning administrator of the municipality that their application to the zoning board was not timely because apparently the planning board had made a determination back in April, 5 months earlier, before it granted site plan approval, that it was a zoning compliant project and it didn't need variances. And since the time to challenge a determination related to a zoning interpretation is 60 days, the zoning administrator said that that was not timely. So the petitioner goes to court, as many do when they are not happy. And again, the court did not address petitioner's substantive challenges, but they had a field day with the procedural issues. So the first was the issue with the 60-day time frame to appeal the determination to the zoning board. And the law is clear, and the court quoted to the provision of state law that says that an administrative official charged with enforcement of the zoning code shall file its determination within 5 business days from the date it is rendered, and that it should be a public record. And once that it is filed, it's from that filing date that starts the time for the petitioner to bring an administrative appeal to the zoning board. In this case, there was absolutely no record that there had been a determination by the planning board, let alone that it had been filed with the town, generally when you say filed, it's with the clerk's office. So in that case, the time to challenge it had never started to run because the procedural steps to make it a valid determination that could be subject to administrative review hadn't happened. But in my opinion, the court never even had to get that far in discussing the filing and all of that stuff, because the bigger issue, the bigger threshold issue, is the fact that planning boards are without power to interpret local zoning law, as that power is vested exclusively in the local code enforcement officials and the zoning board of appeals. So regardless of what determination the planning board had made, it's not its place to do it. The planning board has a lot of power, don't get me wrong, but that's separated out into the building officials, the building inspector, and the zoning board. And it's not the planning board's purview or jurisdiction to be making determinations as to zoning compliance. That's within the purview of the zoning board. So no matter what determination the planning board had made, it would not have been dispositive. And further to the court's point, the proper procedure wasn't filed in terms of filing it, wasn't followed in terms of filing it. And so there was never a time to challenge it. So ultimately, the court just said it's going back to the zoning board, which is where it should have been in the first place, regardless of any claims by the zoning administrator that the challenge wasn't timely. So the next case is Florida Historical Society versus Zoning Board of Appeals of the Village of Florida. So in this case, the Historical Society was bequeathed title to a 14-acre parcel that had been used by the prior owner prior to his passing as his residential residence. The Historical Society wanted to convert the existing building to headquarters space and meeting space and have a museum for its member, and create walking trails on the undeveloped portions of the property. The Historical Society appealed to the zoning board from a determination that the proposed use was not a permitted conditional use or special permit use. The zoning board looked at the code and looked at what the applicant was proposing and said that the board did not think that it was a permitted conditional use, but that the zoning board could grant a conditional use variance. Now, I looked at the Village of Florida code earlier today to try to understand what exactly a conditional use variance is. It seems to me it may just be more akin to a use variance. But for the purposes of this, it's not really relevant. More to the point was that the zoning board determined that this variance was necessary, and ultimately the zoning board did grant it, but first making the determination that it was necessary, secondly, then granting it. But the zoning board's grant of the conditional use variance was based upon the condition that the applicant obtain an approved plan from the planning board. So then the applicant they think they're moving along, they have their approval from the zoning board. Now we're going to the planning board. The planning board hears the site plan application and says, okay, we're going to grant you conditional approval as well, subject to you, Historical Society, giving us a survey of your entire property. So remember, not only did they want to convert certain already developed portions of the property into the museum and the meeting place, but they also wanted to create these walking trails on the undeveloped portions. So it was a conditional approval. You give us the survey of the entire property. For reasons I don't understand, the Historical Society refused to do this. And so ultimately the planning board denied the application. So this put the Historical Society in a really bad spot, because now not only did they not have approval from the planning board, but their zoning board approval was conditioned upon getting planning board approval. So now they had nothing. So they went to court, and they first tried to challenge the zoning board's determination that they even needed the conditional use variance in the first place. Because if they didn't need it, that they weren't bound by the condition on it, that they also get site plan approval. But the court said that it was too late for that. Because they ultimately got the variance, they didn't go to court right away because they didn't think they need to. But the statute of limitations to challenge a determination by the zoning board is only 30 days. So by the time they realized that the interpretation that they needed the variance could be a problem, their statute of limitations had run. And so they were bound by the decision that they needed this variance and the decision to grant the variance, subject to the condition that they get site plan approval. So what do you do then? You challenge the denial of the site plan approval. And they tried to challenge putting the condition on the site plan resolution that they provide a survey of the entire property. And again, the court didn't get into why the survey wasn't provided or what the argument was. And it's really not clear to me, because I know surveys can be costly, but the amount of time and money it must have cost to do this litigation, I just really don't understand it, but I'm just speculating. Anyway, so the court explained that a local planning board has broad discretion in conducting a site plan review and in setting appropriate conditions and safeguard in harmony with the general purposes and intent of the applicable zoning code. So here, basically the court is saying, in conducting your review and making your decision, you're allowed to put reasonable conditions on the approval. And the court found that this was a reasonable condition. And so the planning board's determination was not arbitrary and capricious, and it should be upheld. What I found interesting, though, was that in the discussion of the standard of review, the court made note of the fact that a court may not substitute its own judgment, even where the evidence could support a different conclusion. So it seems like the court was saying, I don't necessarily agree that this was the way to go, but it's not my job to tell the planning board what they should have done. What the court's job is to look at the record and look at what the board did and make sure that it had a rational basis and was arbitrary and capricious. And because that was the case here, the court wasn't going to overturn it. And then for the last case, the J&H Concannon Revocable Trust versus the Building Department of the Town of East Hampton. I'm just going to briefly read the outline on this one. It's a carryover from last time. And basically it's about timing and when to challenge things, which is what we just talked about in the prior case. So in the Concannon case, the court held petitioner's challenge of the building inspector's issuance of a building permit for a restaurant on a neighboring property was untimely, where the planning board had granted site plan approval for the property, which included the restaurant 4 years earlier. So when they went in for site plan approval, in 2011, I believe it was, it specifically said there was going to be a restaurant use. The neighbor was notified of the public hearing. The public hearing notice included the restaurant use. They were present at the public hearing where it stated the restaurant use. So at that point, the court determined that they were on notice of the fact that this use was part of the property. And so it wasn't appropriate for the property owner to then wait 4 years until the hotel tried to get a building permit to put that use into place for them to challenge it. Because like I said, the time to challenge these decisions is very short, 30 days often, as would be the case with something like a site plan approval. Okay, so I think that's it for site plan and special permit.
Okay, excuse me, Christy, I noticed there were a couple of questions. Do you want to deal with those now, since it's somewhat fresh? Okay, well, there was one actually from the first case, the Mueller case. Any information on the status of the constitutionality of the zoning code? This was the dog kennel case.
No, that was separated out into a separate action that would be working its way through the courts. And so that I can't imagine. This decision came down in March of this year to that the constitutionality claim should be pursued further. So I imagine it's still in the Supreme Court, and we probably won't see anything on that for a little bit. But generally, I also only, you know, if I looked at lower court cases too, you guys would be here till tomorrow. So I generally only look for cases once we've made it through a first level of review and are at the appellate division. So assuming if it ever gets to that point, it would probably be a while.
Okay. There's another question. During Article 78, is current or future site work always stopped until a decision is made, or does that require a cease and desist order or some other court decision?
Yeah, generally, if you're challenging a determination that allows someone to proceed with a development, you would also want to seek a preliminary injunction to halt any further activity while the action is pending or the proceeding is pending. That's important for a couple of reasons. First, well, most primarily is that the mootness line of cases when it comes to development is pretty stringent. And so if no one puts you on, even bringing a litigation challenging the approvals isn't enough. You need to affirmatively seek to stop the litigation. Otherwise, if you get whatever you got approved built, 99 out of 100 times, a court's going to say it's moot because the development is done. If you didn't try to seek injunctive relief, it's very unlikely, barring extreme circumstances, that a court is going to make you tear something down.
Okay. And one more before I stop interrupting you. Many examples suggest that, sorry, got someone put the chat in, my message disappeared. Many examples suggest that ZBAs can rely on public testimony concerns over parking and traffic to deny. Are there cases that relate to Article 78 where ZBAs approve and ignore, i.e. fail to discuss, consider, mitigate specific public concern regarding road use and safety?
And that's really fact specific. There's considerable deference given to zoning boards because they're part of the community. They know the area and they're presumed to have a certain level of knowledge and expertise as to what happens in those circumstances. In a lot of instances, they're the, I don't want to say the trier of fact, but they have to determine credibility, and they have to, in their judgment, determine what to rely upon. And if you're getting testimony and you're having people say things on both sides, you have to determine what's credible and based upon your experience and knowledge of your own municipality, what you believe is right. If there's expert testimony involved, then that should be given considerable weight, especially if there's no expert testimony on the other side.
Okay. All right. Since I've already interrupted you, I'll take this opportunity to give out another secret code word. For any attorneys looking for CLE credit, the next word is Cornell. A little tip of the hat to the people who are helping us out tonight, the Cornell Cooperative Extension. So as in Cornell University, Cornell. So that's it for me for a few minutes.
Okay. So we just have one building department case, and this is a carryover from March. So I'm just going to go through it really quickly. In 1998, the petitioner had purchased a 4-story building in a residential district in Queens. It had an advertising sign that was painted on the wall, for which a permit was issued back in 1941. In 1961, the city had prohibited advertising signs in residential districts, but allowed a quote unquote sunset provision. So you could keep the sign for an additional 10 years, or in this case, until 1971. But after that time, the signs had to be removed. However, the building department then issued another permit for the sign, presumably mistakenly, in 1981, and continued to do that for decades afterwards. So petitioner purchases the property in 1998 with the expectation and the economic expectation that he'll be able to lease and make money off of being able to have people pay him to put signs up on the side of his building. Except in 2011, he starts getting hit with various notices of violation, including fines up to $10,000 because he has these signs on his property. So he tried to challenge all these determinations, and understandably so. I'm sure he was incredibly frustrated. He bought the property with the understanding he could do this. He had permits saying he could do this, and now all of a sudden, not only is he going to lose the income from being able to lease the space, but he's getting fines on the other side of it. So he argued that there was a prior precedent because the building department had issued the permits previously, and so they had to distinguish why they were not adhering to their prior precedent, and that is a valid argument. If there are prior decisions that's brought to the administrative agency or officials' attention, they're not required to go seeking out, what happened 60 years ago. Did anyone ever issue a permit under these circumstances? But if it's presented to them, then they're supposed to distinguish why they're not adhering to that precedent. You're not required to adhere to it, but you have to explain why you're not. So in this case, the court said, even in light of that, it still wasn't unreasonable for the court to deny, uphold the violations, because basically the city's argument was, we made a mistake. Like, we shouldn't have done it in 1981. And it wasn't based upon bad faith. The court found that it wasn't bad faith that would have stopped the city from changing its position. But it just shows the latitude that's given to municipalities, both in the decisions that it makes and in correcting past mistakes. Because in this case, the city was just able to reverse course. And because they had a legitimate basis, because you had this law in the books from 1961 saying that this was being phased out, that because they didn't, even though they issued the permits after the fact, it still wasn't good enough. Okay, legislative acts. So we only one case on this. This is Reedman Acquisitions LLC versus Town Board of the Town of Mendon. And this is a doozy. There's a lot to unpack here, so bear with me. So in 2004, Ryan was the owner of the property. It's an 87 acre parcel. And he presented a conceptual sketch plan to the town planning board for a proposed patio home community. The town board was required to ultimately approve the site plan after review and recommendation by the planning board. And because it was going to increase the density over what was allowed under the current zoning, he also needed a zone change from the town board. So in 2004, the town board approved the rezoning of the property from residential agricultural to planned unit development, PUD. However, it did so by a 3-2 vote. And the court doesn't really explain what happened back in 2004, but for some reason, the town board believed that it was required to approve this by a supermajority vote based upon state town law, New York town law, section 265. And this sets forth that if certain property owners within the vicinity of a property that's seeking a zone change file what they call a protest petition, then if the town board does go forward with the rezoning, then it has to be done by a supermajority 4-1 or 5-0 vote. That's assuming it's a 5-person board. Therefore, by adopting it by 3-2, the town board, had actually approved it, but hadn't really approved it because they thought that wasn't sufficient. So Ryan brought a proceeding to compel the town to effectuate the zone change on the ground that only a supermajority was required. And the court agreed with him and said, for whatever reason that I can't really speak to, either the petition wasn't valid or there wasn't a petition filed, that the town board didn't need a supermajority vote. So I don't know if the town was trying to be cute and try to, cover it both ways back then and say, well, we approved it, but what can we do? But ultimately the court said, no, you approved it and you did it by 3-2, which is all you needed. So go ahead and enact your law. But without making it that nice, the court said, enact your law. So that's what the town board did. And the project moved forward. In 2005, the planning board granted preliminary site plan approval, but as a condition of the approval, the town had to enter into a sewer agreement because the project didn't have sufficient sewer capacity. So they had to enter into an agreement with the neighboring town of Pittsford to connect to Pittsford's sewer system. And this agreement was actually entered into in 2006. After a lot of back and forth over the years, the prior owner, Ryan, determined that the development was not economically viable and allowed the site plan to expire in 2015. So now you bring in Reedman, the petitioner in this action proceeding. He purchases the property in 2017 and he's all gung-ho and he's going to make it work. He's going to find out how to make it financially viable. So they start approaching the town and saying, hey town, remember us. You put our property in the PUD district a while back, just want to make sure that's still the case. And when the town found out about that, they went into backtrack mode. The town just unilaterally decided that the sewer agreement they had entered into in 2006 was null and void. They determined that the property had reverted back to the residential agricultural district because the site plan approval had not been taken to fruition, to completion, and had expired in 2015. And then the town board actually took the extra additional step of affirmatively rezoning the property again to memorialize the interpretation they had already made that it should be back in the residential agricultural district. The town board also made an effort, presumably, to negotiate a new sewer agreement with the town of Pittsford, but ultimately denied approving the contract in 2019. In addition, while the applicant had gone to the planning board and received a favorable review and recommendation, the town board, which is the board that ultimately has to approve site plan approval under their code, refused to hear the site plan application. So what did petitioners do? They went to court and they had a lot of complaints. So the first issue was the reversion of the zoning. And in discussing this issue, the court explained that zoning regulations must be strictly construed against the municipality that enacted and seeks to enforce them, and any ambiguity must be resolved in favor of the property owner. So if there's any way to interpret this as saying that the property is still in the PUD, that's what they're required to do. It has to, if there's going to be a reversionary concept incorporated into a zoning ordinance or a local law adopting the zoning ordinance, that needs to be abundantly clear. Here, there wasn't even an ambiguity to construe in favor of the applicant because the local law was silent. It didn't condition the rezoning on anything. It just said your property is now in the PUD. So the court said, that's it. It's in the PUD. There was no basis, town board, for you to say it reverted back to the residential agricultural district. And there was no further basis for you to affirmatively adopt a local law doing that. So the court said this is still in the PUD and the PUD zoning can still be used for this project. So the second issue was the consideration of the site plan application. And on this point, the petitioners moved for mandamus relief. And we talk about this sometimes in prior sessions in the context of, you see it most often, I think, in the building department, because mandamus actions proceedings are not easy to establish because it's basically compelling a department, a municipal employee or an agency to do something. So it has to be something that's mandatory. It has to be something that's not discretionary, and the petitioners have to have a clear right to the relief sought. And in this case, the court said that what the petitioners had a clear right to was to have the town board consider their site plan application, not necessarily approve it, but it had to be considered. The town board couldn't just sit on its hands and say, we're not going to do anything with this, because under the code, it's the town board's jurisdiction to review site plan applications. And so they had to do that. And so the court said that the town board has a clear non-discretionary obligation to consider the favorable report and revised application. So the third issue was the sewer agreement. Under town law, the town board has the authority to enter into contracts. So this is a little bit different than an agency action like site plan approval or a zoning or a variance. This is something that legislative that the town board is authorized to do under town law 64-6. So in deciding not to approve the new sewer agreement with Pittsford in 2019, the court said, fine, town board, it was within your discretion in your legislative power to decide not to approve it in 2018, because you could have reasonably determined that you didn't want to have to negotiate and enter into a contract with a neighboring municipality to purchase sewer services from them. But that was really an irrelevant page of the court's decision, because then the court went back in time and said, well, fine, we gave you a break there, that it was okay for you to not enter the agreement in 2019, but you never even had to do that because you didn't have a right to unilaterally cancel the 2006 agreement. So that's actually still in place. What they said was that that was basically a contract issue. The sewer agreement just said that it was good to remain in full force and effect for 40 years and can only be changed, modified, or amended in writing by the parties' mutual agreement. So the town board did not have the authority to just out of the blue say that it was no longer in effect and kind of try to start this process over and then delay and ultimately deny it. They had to go forward with the agreement. And if they had wanted to put in the agreement that if the applicant did get site plan approval or whatnot, then the contract would be null and void. That could have been done, but it wasn't. And then the last issue that the court addressed was attorney's fees. The lower court had actually granted petitioners attorney's fees based upon separate constitutional law claims that they had brought, namely substantive due process and equal protection violations. But even after everything that had happened and everything the town had done to try to, not let this project go forward, the court did find that the granting of attorney's fees was improper. And essentially, the reason why the court found that was because the finding was that they were insubstantial, the petitioner's constitutional claims, which is basically saying there was no way that they could prevail on them. So with respect to substantive due process, this requires the petitioners to show that they had a vested property interest or more than a mere expectation or hope to obtain approval of their application. And the court found that there was nothing in the record to establish that they had a vested interest in an approval, because the town board still had to hear the application, and under the code, the town board had considerable discretion as to whether it actually granted the approval. And based upon past events, it seemed pretty unlikely that was going to happen. So without being able to demonstrate a vested interest, a vested property rights interest, the substantive due process claim wouldn't fly. And so that was not a basis for attorney's fees. And with respect to the equal protection claim, the court found that this claim failed because the petitioner could not identify other parcels or developments that were similarly situated to them and that were treated differently and specifically better than they were being treated. And so in order to demonstrate equal protection claim, you can't just say, you have to be able to demonstrate it based upon other properties and other property owners, and they couldn't do that here. So even after everything that had happened, the court said, the court gave them a roadmap forward, said you still have your zoning, you still have your contract for sewer, but you're not entitled to attorney's fees, and who knows what the town board's going to do with your site plan application. Okay, area variances. So we had some of these sprinkled in a little bit earlier, but now we'll get into a little bit of the substance of what it looks like. So the first case is Parson versus Zoning Board of Appeals of the Village of East Hampton. Petitioner had an office building with 4 offices that had been approved under prior parking regulations, which it complied with. The village then subsequently intensified those parking requirements. So this use would have required more parking, but the village said, you know what, if you got approvals and you're existing and you're compliant with the existing parking, we're not going to make you comply with these more stringent requirements unless you decide to intensify your use. So at some point in time, the building department, I don't know if they were doing inspection or what happened, they came to realize that, hey, they don't have 4 offices anymore. Now they have 6. So now who knows how long that had been in existence or under what circumstances it happened. But the reality was what they were approved for and that what they were allowed to have legal non-conforming under the prior zoning was their 4 offices. So now they had 6. So they had to go, in order to keep those 2 extra offices, they had to go to the zoning board for an area variance. And so now I'm just going to quickly, the court went through what the standard for an area variance is. The zoning board must weigh the benefits to the applicant if the variance is granted against the detriment to the health, safety, and welfare of the neighborhood. And in doing so, there are statutory criteria, which is set forth in state law. There's separate state law for towns, villages, and cities, but in many instances like this one, with respect to land use, they do all mirror each other. So these criteria are set forth in all 3 of those and state that the zoning board must consider 1, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by the granting of the variance, whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance, whether the area variance is substantial, whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions of the neighborhood or district, and whether the alleged difficulty was self-created. This consideration is relevant to the decision of the Board of Appeals, but shall not necessarily preclude the granting of the variance. And this is a balancing test. You don't have to satisfy all of them, unlike with the use variance, which we'll talk about in a little bit. So ultimately, the court ended up upholding the zoning board's denial of the area variance, finding that the zoning board engaged in the required balancing test and considered the statutory factors. The zoning board found that the variance would exacerbate existing parking problems within the building, and granting of the variance would set a precedent within the village. And the hardship was certainly self-created, as the owner was presumed to know what the zoning regulations were when they purchased the property, and also when they changed the use to 6 offices. And with respect to substantiality, this came down to a difference in interpretation between the property owner and the zoning board, because the property owner had 23 parking spaces, and under the prior zoning, he should have only needed 2 additional spaces per office, a variance of 4 spaces, which could arguably be said to be not substantial. But because the zoning board took the position that, well, under the code, you intensified your use, so now you need to comply with our more stringent parking requirements, that changed the variance from 4 spaces to 20. And that made the variance a lot more substantial. And it seems like the board was probably going in the direction of denying that anyway. But a change in substantiality to that degree certainly didn't hurt the zoning board's case. So the next case is Oconnor and Sons Home Improvement versus Acevedo. So petitioners had a vacant lot and sought to subdivide it into 2 lots and put 1 house on each. The lot was conforming as to lot size as 1 lot, but with the proposed subdivision, both lots would be undersized. And so they would require lot size variances from the zoning board, which the zoning board heard and ultimately denied. And the court started its analysis by explaining the deferential review that's afforded to zoning boards. Local zoning boards have broad discretion in considering applications for area variances. Courts may set aside a zoning board determination only where the record reveals that the board acted illegally or arbitrarily, or abused its discretion, or that it merely succumbed to generalized community pressure. And what the court basically said was, you did all of those things in denying this variance. And so the court ultimately overturned the zoning board's denial, finding that it was not supported by proof. All they had was conclusions of fact. And this goes back to one of the issues that we were discussing earlier. The petitioners had submitted expert testimony with respect to the impacts of the traffic and parking and whatnot. And in response to that, the zoning board just relied upon generalized community opposition. So, while the zoning board does have discretion to determine the credibility of what it's hearing, if you have someone with expertise that's telling you something, and there's nothing coming in on the other side, then you have to give that a decent amount of credence. And that's not what the zoning board did here. The zoning board also failed to adhere to its own precedent, because apparently the petitioners had demonstrated that the zoning board had granted applications similar to this on pretty much the same facts. Once that information, as I said earlier, is presented to the board, it doesn't necessarily mean you have to follow it, but you have to explain why you're not following it. And the zoning board didn't do that. So without actually analyzing the specific statutory criteria for an area variance, the character of the neighborhood, substantiality, alternatives, the court overturned the zoning board and said, you were wrong. This record does not support what you did. And I actually looked to see what the board ended up doing, because sometimes they'll say you should have granted the variance, and sometimes they'll say go back and put together a record that can support what you tried to do. But the court actually didn't do anything in that case, so I don't really know what ends up happening after that. I guess they make another application to the zoning board. So the next case is Capitola versus Town of Riverhead. And so Hocker was the owner of the property, and he had a vacant parcel that he wanted to construct a single family home. The building department determined that four area variances were required: impervious coverage, front yard setback, side yard setback, and combined side yard setbacks. So he goes to the zoning board for the variances. They notice the public hearing, and the public hearing comes, and the neighbors show up, and they're opposed to the construction of a single family home on a vacant lot, which, I guess isn't uncommon. But one of the arguments that they raised before the zoning board is that, hey, he also needs a lot size variance. That wasn't included in the building inspector's determination, and that he hadn't applied for to the zoning board. So ultimately, the zoning board did approve the 4 variances and made a determination that a lot size variance was not needed. And then petitioners brought an Article 78 proceeding challenging that determination to grant the variances. So the court upheld the granting of the 4 variances, finding that the zoning board did engage in the requisite balancing test and considering the relevant factors. But with respect to the lot size, it appears that the court may have agreed with petitioners that the lot size variance was necessary, because what the court said was, even if the property owner did require a lot size variance, any error on the part of the zoning board on this point was not a basis to send the application back to the zoning board for a new determination. And the reason for that was the zoning board's determination jurisdiction is appellate only. So it only has the authority to review a determination that has already been made by the official charged with enforcement and interpretation of the zoning code, which is generally either your code enforcement officer or your building inspector. And then that determination has to actually be appealed to the zoning board. So in this case, the property owner had a determination that he needed 4 variances. So he went to the zoning board for the 4 variances. While you could interpret that as a determination by omission that the building inspector was finding that a lot size variance was not needed, then that should have been separately appealed by petitioners, the neighbors, to the zoning board. But they didn't do that. They just showed up on their neighbor's application for the variances to try to construct his home and said, we think you're wrong. But they didn't take the affirmative steps they were supposed to take in order to preserve their rights and timely exhaust their administrative remedies. So now by the time the court is making this determination, the 60 days to challenge any sort of building inspector determination has long since passed. So the neighbors were out of luck because they didn't take the steps that they were supposed to take. And the next case is Carl Myers Enterprises versus Town of Kinesis Zoning Board of Appeals. So this doesn't have a lot of facts, but it raised what I think is an interesting procedural issue. So in a prior court proceeding, the court had directed the zoning board to revisit a determination it had made on the petitioner's zoning application. So at some point in time, they don't go into a lot of facts about when it was. The zoning board had made a determination. That determination got challenged, and the court remanded it back to the zoning board for further consideration. So it goes back, which, as I was saying earlier, is usually one of the things you see happen when a court overturns a zoning board determination. So it goes back to the zoning board, and the zoning board denies it by a 3-2 vote. So petitioner, in what seemed to be a somewhat interesting argument, claimed that the denial wasn't valid because it wasn't unanimous. So why would a denial under these circumstances have to be unanimous? So petitioner pulled out New York Town Law 267A12, which is not a very often referenced provision, but basically it allows for zoning boards to hold what they call rehearings under certain circumstances, but you have to follow the procedure very closely. And what the procedure says is that the zoning board can decide of its own volition to rehear an application that it's already ruled on. But in order to do that, they have to vote unanimously of all of the board members present at the meeting that they want to do this, that they want to hold this rehearing. Then it has to be noticed. Obviously, notice has to be given to the property owner of whatever application they're rehearing. And then you hold the public hearing. And then if the zoning board wants to act in a manner that's contrary to their prior action, it would have to be done again by unanimous vote of the board then present at that meeting. So I think petitioner found this provision, and because technically the zoning board was hearing this application for the second time, the petitioner kind of tried to extrapolate this concept that if you're going to change your mind from what you previously approved, then you have to do it by unanimous vote. And the court said, nice try, but no. This was not a rehearing under 267A12. This was a court telling the zoning board, hey, look at this again. The zoning board didn't take it upon themselves one night to say, we want to rehear this. A court told them they had to rehear this. So the provisions for this rehearing concept were never implicated in the way that petitioner was claiming it would. And so consequently, the unanimous vote provision also did not apply. And so the fact that it was denied by a 3-2 vote did not render it invalid. But as a result of that, this was actually the argument that the lower court had agreed with. The lower court so the appellate court had to overturn the lower court. But the lower court was presented with a variety of arguments and didn't rule on them, only ruled on this argument that it had to be unanimous. So now after all that time of appealing, going to the lower court, appealing to the second department had nothing else in front of it to look at, because the only decision that had been made was that it had to be unanimous, and it wasn't. So after the court determined that that wasn't right, it has to go back to the lower court for the lower court to assess the validity of all the other arguments that petitioners had made for vacating the denial of the variance. So it's just time, and more time. And that's it for area variances. Moving right along. So we just have one use variance case. I didn't really see many, it's always kind of cyclical. And like I said, there were a lot of special permit cases. Last time we had a bunch of use variance cases, but not that many. This is actually a carryover from last time, but I left it in just because I wanted to be able to address the standard, and it does raise some what I think are interesting issues. It's okay if you don't think they're interesting. WCC Tank Technology Inc. versus Zoning Board of Appeals of the Town of Newburgh. So back in the 1980s, petitioner's property had been granted a use variance to operate a fuel tank lining business, subject to certain terms and conditions. In 2017, so 35 odd years later, the building department received complaints that the property wasn't just being used for a full fuel tank lining business, but also for support to a hydro excavation business, which included outdoor parking of Freightliner trucks. So the building department pretty much said, you can't do this. This isn't part of your use variance. So the property owner went to the zoning board and sought to have the use variance broadened to include this hydro excavation business use. And what the court said with respect to the prior use variance was that a use for which a use variance has been granted is a conforming use. And as a result, no further use variance is required for its expansion, unlike a use that is permitted to continue only by virtue of its prior lawful non-conforming status. So this is something we had talked about before. If you have a use that predated zoning, and then ultimately zoning regulations were put into place that rendered it not conforming, that use could continue, but generally subject to restrictions based upon the zoning code, which often, as I mentioned, includes not expanding, not extending, not enlarging that existing use. So what the court's saying is that's not the case with use variance. Once you get a use variance, you can do whatever you want with respect to that use on the property, subject to whatever conditions were put on the use variance approval in the first place. So the point was that if they had this use variance to do their fuel tank lining business, they were allowed to do that fuel tank lining business anywhere, but it didn't allow them necessarily to then incorporate this hydro excavation business if it wasn't allowed by the conditions. And that's exactly what the court found was the case, that the use variance that had been granted pretty much limited any expansion to that fuel tank lining business and not to any of these other subsequent businesses that the petitioner tried to put on their property. So then they went through the use variance for criteria to see if the petitioner could separately justify having this additional use, this hydro excavation business use, incorporated into their property. And so the standard for use variance, much more stringent than an area variance. Unlike an area variance where it's a balancing test and the ZBA kind of has the discretion to say which factors weigh more than others, what's substantial. Here, the factors are more stringent and they're all required to be satisfied. And it's a difficult standard. That's why a lot of times when you see people who have a property that doesn't comply with zoning, their first inclination isn't to go get a use variance, it's to try to change the zoning. Because as hard as that sounds, because you have to go to the legislative board and they're completely within their discretion not to consider it, trying to get a use variance is a very difficult thing to do. So the standard for a use variance is that the applicant cannot realize a reasonable return if the property is used for permitted purposes under the current zoning. So the applicant would have had to demonstrate that for the use they already have, their fuel tank lining business, and every other use that's permitted in their zoning district, they cannot realize a reasonable rate of return unless they have this hydro excavation business. And that has to be demonstrated by dollars and cents proof. You can't just say it and have it be enough. You need to actually have tangible numbers, records, probably from an accountant to demonstrate that that's the case. And that's really hard to do. And ultimately in that case, like I would say 99% of the cases, that's what this petitioner got hung up on because he couldn't make that demonstration. And because use variances require establishing all of the criteria, once you're out on that first one, the boards don't even continue looking at the other criteria because it's a waste of time. But the other criteria are that the hardship results from unique characteristics of the property, that the proposed use would not alter the essential character of the neighborhood, and that the hardship has not been self-created. And the self-created factor is also a factor in area variances. But in area variance law, it specifically said that it's not determinative on the decision. Here, it is determinative, just like proving a reasonable rate of return. If you can't prove that your hardship isn't self-created, then you're not going to get your relief. And that's a really challenging thing to do, especially because there is this presumption that people know the zoning of their property when they purchase their property. I mean, I don't really think that's a realistic way of looking at it, but the law is the law, and people are presumed to know the law. So just saying, I didn't know what my zoning district was, it's not going to fly. So that's another challenging element of the use variance criteria as well. So, and in that case, when it was applied to this property, it was determined that they didn't prove their entitlement, and so they weren't allowed to keep their hydro excavation business, but it didn't interfere with their prior use variance. Okay, SECRA. We got a couple. Right. Yeah.
Do you think it'd be a good idea before we move on to SECRA to check out a few questions?
Sure.
Okay. Before we do that, I'm going to give another code word for any attorneys out there. Third one is autumn, as in the synonym for the season fall, AUTUMN, autumn. Just going back in the chat a little bit, there was a question. This is going back to the injunctive relief. Don't you need to put up a bond to get injunctive relief?
Yep. So to prove your entitlement to a preliminary injunction, you have to demonstrate a likelihood of success on the merits, which is basically, whatever you're challenging. If you're challenging a variance, if you're challenging site plan approval, you have to show that there's at least a likelihood that you're going to ultimately win in court. You have to demonstrate that, but for the injunctive relief, you'll suffer irreparable injury. And that's usually pretty easy to argue because, if you don't get the injunction and they build the skyscraper, then, that's your harm. And the balance of equities, which is more factual based and just kind of looking at the overall situation. But if you can demonstrate your entitlement to a preliminary injunction, except in some specific instances, I think generally involving municipalities, the general rule is that it is mandatory for a bond, an undertaking, it's referred to be placed up by the party that sought and got the injunctive relief, pretty much as security in case it's ultimately determined at the end of the litigation that that party was not entitled to the injunctive relief. And so that the bond is supposed to be set in an amount that would make the property owner that was enjoined whole as a result of having the injunction placed on them.
Okay. Another question, I think this is in response to your answer about expert testimony. In that circumstance, does the ZBA member need to comment on the testimony provided to add their own opinion on the record? I believe that was going back to when you were talking about one side having expert testimony and the other side not.
I mean, I think the board is certainly entitled to consider whether they find it reliable, but there's a presumption when it comes to expert testimony. If you have an engineer, if you have, a traffic consultant, if you have something like that telling you that these things are not going to be issues, and then, people on the other side are just saying traffic's going to be an issue, but without anything backing it up, that's going to be difficult to overcome in a court.
Yeah, in the absence of expert testimony on both sides, I believe the ZBA would be able to just, make a determination on their own, but it's probably the best that they make it explicit and put it on the record. I think that's one of the concerns the writer had.
Well, yeah. And this is something that we talk about a lot. Making your record, absolutely. Because that's what the court is looking at, right? When the court is looking at, was it appropriate for the zoning board to grant a variance? Was it appropriate for the planning board to deny a site plan? All they're looking at is what was before that board when they made their decision. So the more facts you have in there, the more reasoning you have in there, the more explanation you have in there, the more detailed of a resolution you have outlining the reasoning for your decision, the easier it's going to be for a court to see your perspective and understand why you reached the decision you did.
Okay. Another question. In the Astoria Landing, that was the case with the sign, I believe.
Mhm.
Even if the municipality did not act in bad faith, would the sign then become a pre-existing non-conforming use?
That would have been the general practice, except for that sunset clause that they had in the law. So generally, in specifically that situation, if you have this sign that's been on the side of the building since 1920 or 1940, and then the municipality enacts a law that says you can't have signs on the side of your building, the general practice would be then it becomes legal non-conforming. And so it would be allowed to continue in its current format. You know, if you're using up one floor of your 4-story building with a sign, you can't then use the whole entire side of 4 stories. You can't expand it, you can't enlarge it. But generally, the principle is that those legal non-conforming uses will be allowed to continue under those circumstances. This was unique in that the city built in a sunset clause that says, we're going to give you some time to figure this out. We're going to give you 10 years, but after that, you're done. It's not allowed at all. And that was what made this situation unique.
All right. If there is a rezoning for a specific plan and a subdivision is filed based on that specific approval, but the subdivision is never developed and the entire land gets sold to a new developer, then does the conditions on the zone apply to the new owner?
That's challenging to speak to because that's very fact specific. I don't know what kind of conditions would be put on a rezoning. If the property has been approved for subdivision and the subdivision plat has been filed, that should be the end of the subdivision process. Under state law, there are certain periods of time within which after you get your subdivision approval, you have to file your plat. And that's why often you'll see people coming back in for extensions because the time is really short. And generally there are a lot of conditions on the subdivision approval that have to be done. You have to get sewer sign off, water sign off, various county departments before you can even get it filed. So by the time you get it filed and it's done, that should really be the end of the process. So I'm not sure at that point what other conditions would be on the approvals.
I'm wondering if the person asking the question might have been speaking about like a PUD type, development where, or a floating overlay zone, I should say, where maybe the village or town board rezones parcels just for a specific project rather than just changing a zone from one established zone to another.
Well, yeah, sure. I mean, I think that makes sense that you rezone something based upon what's being presented. In some instances, sometimes, you just have a global plan and you think this will be better in that zone. But if it's a request to rezone based upon a specific project, but if it's a request to rezone based upon a subdivision and the subdivision plat is filed, unless they wanted to modify the subdivision or make more lots, I'm not sure how specific a rezoning would be on the conditions of that subdivision. Like if they decided to put 4-story houses on instead of one family houses, that probably wouldn't fly. But I don't know. I mean, I guess it's possible if a legislative board would be that specific in its conditions as to the layout of the lots and that type of thing.
Mm-hmm.
That's just not something I could really speak to on a general basis.
Okay. With an area variance, can the original intent of the zoning be considered, or must the ZBA only consider the criteria you mentioned?
I think if it's available, why not? One of the criteria is the character of the neighborhood and detriment to nearby properties. So if the legislative board has made a finding that this is permitted, X should be permitted in the district and someone is proposing Y, I think it's a factor you can consider. But the code also allows for this process of having people be able to get variances, especially, you know, the less stringent area variances. So I don't know. I don't think it could be dispositive to say, well, the code requires 10 feet. So it's against the intent of the code for me to give you 5 feet, because then variances would be obsolete. They would never be granted.
Okay. There's another comment. I'm not sure how this fit in the context, but it just says that doesn't make sense. If a building inspector turns down an application, the neighbors are not aggrieved. That must have been the case with the 4 variances and the building inspector determining that it did not need a lot area variance. I'm not sure what the question is, though.
I mean, neighbors challenge determinations all the time. You know, you have instances all the time where a zoning board decision granting a variance, a zoning board grants a variance, and then the neighbor challenges it. I mean, to say that they're not aggrieved, I don't know that that's correct.
Scrolling through here. Can we ask about area variances regarding Capitola? Building inspector decision are sent to property owner. Neighbors may never know of a building inspector denial. Until a neighbor gets notice of a ZBA hearing, how can they know of a decision to be able to initiate their own appeal? Seems like there must be some kind of administrative procedure for a neighbor to address this. What would that be?
Well, you're getting notice of it, so you know that the determination has been made. I think you can argue that, you know, you were only constructively aware of the existence of the determination when you received the notice of the zoning board meeting. And that was the situation that we talked about with the hotel, where the hotel had actually been granted a certificate of occupancy in 2005. And it included the restaurant use. The court didn't say you were supposed to challenge the building permit and certificate of occupancy that were issued in 2005, because it was unrealistic to think there would be any reason for the neighbor to be on notice of that. But what the court did say was, when you got notice of this site plan application, you got the public hearing notice and you came to the public hearing and you heard discussion about the existence of the restaurant, then you were on notice of this. And so that was your time to challenge it. So I don't think the courts, based upon that, I don't think the courts would bind someone if they didn't know about it. But what you can't do is then do what the person did in that case and wait 4 more years until the hotel goes in for a building permit for the restaurant and then try to challenge it. It's a question of reason.
Let's see. For use and area variances, if they are owned by an LLC and an owner of the LLC applies for a variance, is the application supposed to be done based on the LLC ownership or the owner of the LLC?
I mean, someone can authorize a representative to make an application on their behalf. So if it's an LLC, you can make it as the LLC, or you can have someone who's authorized to act on behalf of the application. A lot of municipalities, if someone who is not the legal owner is submitting an application, there's an owner affidavit that has to be signed off on by someone with authority saying that they authorize the making of the application. So I think that's really something that's handled administratively on a case-by-case basis. I mean, the owner of the property certainly has to be involved in the process, but the owner could certainly authorize someone to act on their behalf.
Okay. All right. Well, there's another word. I don't want to start skipping. I know Secra and Arlupa are some pretty intensive issues, so I'd like to get going. There is a question, but it looks like a rather specific one. And as I said at the beginning, I think we should be avoiding specific development questions. I mean, you're not in a position, because you don't know the facts of them, to answer them.
Right.
So I think we should get back to your presentation, and hopefully we'll have some time to answer some more questions at the end.
Okay. State Environmental Quality Review Act, SECRA. It's come up a few times already today. There's 4 cases. These, I'm going to go through the first 2 in detail. And then I think the second 2 are, it's fine to just read what's in the handout because that's really the crux of what I was trying to get at with raising those cases to begin with. So the first is Peachin versus City of Oneonta. Parkview had submitted a proposal to the City Planning Commission to construct a 73,000 square foot 4-story mixed-use building. The development was going to include 64 affordable housing units that were going to be marketed to local artists and middle-income residents. It also included the construction of an educational facility that was going to be developed in conjunction with nearby Hartwick College to provide testing, product development, and support resources for local grain industry professionals. But the proposed location of this development was going to be on an existing municipal parking lot that was 2 acres in size, and the development itself was going to be 1 acre. So the planning board served as lead agency pursuant to SECRA and issued a negative declaration finding that the project did not have the potential for any significant adverse environmental impacts. The SECRA determination is a prerequisite that must be made before any action can be taken on the underlying application. So once the SECRA determination was done, that it was a neg deck, no further review was needed environmentally, and then the project can move forward to the site plan review phase, which is what happened, and the project was approved. In granting site plan approval, the planning board exercised its authority to waive parking requirements. Even though the project was going to result in a loss of 84 spots from the development being on a parking lot and 90 spots were needed from the project, the planning board determined that there was sufficient reserved parking to accommodate the development. And pretty much immediately after the planning board approved the site plan, the mayor of the city entered into a purchase and sale agreement conveying the property to this Parkview entity. Petitioners, which were nearby property owners, challenged the planning board's actions and the conveyance of the property. And the first issue, which is a threshold issue we often hear, is standing. And standing is your justification to the court that you belong there. You know, you can't just sue for no reason. There, you have to have some investment in what your issue is, what your concern is. And so in the context of standing, the petitioner has to show that they suffered an injury in fact, and that the injury was within the zone of interest intended to be protected by the statute. So injury in fact, that's related to SECRA, which is environmental. So you have to allege an injury that's environmental in nature. As these were often business owners that were neighbors of this property and were concerned about losing the parking that was available to them, their concerns were generally economic in nature. And so the court said that's not a basis for you to bring a SECRA claim because SECRA is not concerned with economics. SECRA is concerned with environment. So that was not sufficient to confer standing. In addition to having it be an environmental harm, it has to be a harm that's different from the public at large. So one of the other arguments that was made for standing was traffic. The court said that traffic is something that pretty much anyone in the city, anyone in the state could argue anytime they go down the street. If they hit traffic because of this development, they could argue they're harmed. So it needs to be more specific than that. And lastly, the petitioners argued that they would be harmed by the obstruction of scenic views from the development. And the court said, you know what, you may have something there. It's an environmental harm, and it's not something that's going to be suffered by everyone because you guys have these business locations. And so your views are unique to you, but you didn't do a good enough job of arguing it or alleging it in your complaint. So you still haven't done enough to show me, but it's possible that that could be enough for standing. But since there was no standing, what the court under normal circumstances would have done is just said, well, there's no standing, so there's nothing for us to consider, the case is done. But perhaps it was because the lower court had gone into a subsequent analysis of the merits of the arguments that the appellate division decided to do so as well. So the substantive standard for a SECRA review is whether the lead agency took the requisite hard look at the potential impacts and made a reasoned elaboration for the basis for its decision. So the court found that the Planning Commission did do that with respect to parking, which was, as I mentioned earlier, the major issue for this project, because we were losing all that parking related to the municipal lot. And the court noted that the planning board had actually relied upon a parking study that had been prepared by an independent consulting firm that identified that there was ample parking available in the district, and also noted that there were 2 other projects that had been proposed in that area but never went forward. So you had all the reserve parking from those projects that weren't going to be interfering with this project. So the court was satisfied under those circumstances that the planning board had taken a hard look by investigating these issues, having studies generated and experts weighed in, and then making a reasoned explanation for how it reached the conclusion that there were not going to be any significant adverse environmental impacts on parking from this project. And what the petitioners next argued was that by the city conveying the property to the Parkview, the developer, to create this project, it was going to be a violation of the public trust doctrine. And what the public trust doctrine says is that once a municipality has property in its possession that is being used for public use, it can't be conveyed or used for a purpose that is exclusively private. So in this case, this parking lot parcel had been conveyed to the city back in 1922, and it was pursuant to a will, and it specifically said that the parcel had to be used for public buildings and for parks and municipal purposes. So generally, this would seem to be a situation where the public trust doctrine would apply, in which case the municipality could not then change that use to private unless it obtained approval from the state legislature, which is complicated and does not happen very often, and often involves some sort of land swap. But in this situation, the court said that there really wasn't an issue with the public trust doctrine because of the proposed use of the property. So the proposed use of the property, as I mentioned earlier, was affordable housing and a collaboration with the local college that would serve a public use by allowing nonprofits to go there and do their testing and studies for agricultural purposes. And so the court said, you know, we think the argument could be made that that serves as a public use. And so under those circumstances, we don't think it violates the public trust doctrine. So the next case is Coalition for Cobbs Hill versus City of Rochester. So we had an existing 60-unit affordable housing development, and Plymouth, the property owner, was proposing to demolish it and construct a new development with 100 units. The petitioners who were challenging this were tenants of the current residential development, who naturally were not happy that they were going to have to leave and their property was going to be torn down, and other organizations that were representing the tenants and neighbors. And they challenged virtually every aspect of the seeker review. So with respect to the substance of the petitioner's challenges, the first one was questioning whether the zoning manager of the city could be lead agency. And the court cited to the seeker regulations, which state that a lead agency is an involved agency, and an involved agency is an agency that has jurisdiction by law to fund, approve, or directly undertake an action. So basically, any person or agency or entity that has discretionary authority to make a determination with respect to any aspect of this project can be an involved agency. Generally, you wouldn't see it be someone like a zoning manager. You would usually see it be an agency like either the city council or the planning board or something like that. And I think that's why the petitioners harped on it, because it was out of the norm, and they argued that the other boards were doing this in order to shield themselves from the public scrutiny of the project by having the zoning manager take on the hard work of being the lead agency and basically being the face of making the environmental determination with respect to this project. But the court said it was appropriate under the regs. And so there was no reason that the zoning manager couldn't be lead agency and couldn't make these sacred determinations. So then the next question was, did they do it properly, substantively, and procedurally? And the court found that they did. The court said that the zoning manager did take a hard look at the potential impacts and provided a reasoned elaboration for its determination. With respect to traffic, they had both an independent consultant and the County Department of Transportation review the project, and both determined that there would not be a significant traffic increase during peak hours. The zoning manager also identified mitigation measures in the form of an additional road entrance to offset the increased traffic. One of the arguments that was made was that there were potential impacts or areas that the zoning manager did not look at. And in response to that, the court said that the zoning manager was not required to look at every possible permutation of how traffic may be affected by the project, because that would, quote, abandon the rule of reason that governs the secret analysis. So hard look, the substantive standard of review, does not require every minutia or detail of the project that could ever potentially come into play. Otherwise, you would never get over the secret hurdle. You would be stuck in this revolving door forever. So it does leave some discretion and flexibility and uncertainty as to what constitutes a hard look. But so that's why I'm trying to give you some examples of what the court looked at in these situations and said, okay, well, you had a traffic study, you had the county look at it, you had some proposed mitigation. So, you didn't have to look at everything in the universe, because that's really just not feasible. So the second primary environmental issue that had come up during SECRA was potential lead contamination. And with that respect, the zoning manager had relied upon a soil study to indicate that there were no metals located on the premises. The court also rejected arguments that petitioners raised that there was lead contamination on the project site based upon an alleged shooting range that existed over 100 years ago. And the court shut that down. And that goes back to the issue that we talked about a little while ago with the record. And the court said this was never brought up, this concept of a shooting range and lead contamination related to, bullets or whatever. That wasn't raised at all during the SECRA process. It's not in the record of what I'm looking at. So how can I, as the court, judge what the zoning manager did in that situation where the zoning manager didn't have that information and petitioners only raised that for the first time before the appeal? And so that's the concept of it dehors the record to put information in front of the court that the agency or board or person making the determination that made the determination you're challenging didn't have in front of them, because that's not the court's standard. The court's standard isn't to make the decision that ought to have been made. It's to review the information that the board had and determine if based upon that, they satisfied the standard. So in order to be able to say whether the zoning manager took a hard look at whether there was potential contamination relating to a shooting range, the zoning manager had to know that happened. And because they didn't, because the petitioners only raised it for the first time in litigation, the court said, I'm not considering it. The next issue is with the typing of the action. There's three types of actions. There's type 2s, which is a list that's laid out in the SECRA regs. And if you're a type 2 action, then you're pretty much you've been determined that as a matter of law, your project is not going to have a significant adverse environmental impact. You see that most in area variances, because generally they're 1, 2, 3 family area variances. You have the type 1 actions that are the ones that do have a presumption. They're the much bigger projects. They're rezoning the large multifamily residential developments, developments that are close to historic places or parks and whatnot. So those are the ones that do carry with them the presumption that there could be the potential for a significant adverse environmental impact. And what petitioners argued in this case was that because it was a type 1 action, there should have been a positive declaration that required the preparation of an environmental impact statement. And the court said no. While generally that's the presumption, it's certainly a rebuttable presumption. And in this case, the record did demonstrate that the zoning manager was able to reasonably determine that there was not the potential for any significant adverse environmental impacts that would require a pause deck and the preparation of environmental impact statement. And so the court upheld that. And the last secret issue was a conditioned negative declaration. The petitioners claimed that because there were certain mitigation measures that were implemented as part of the neg deck, that it was a conditioned negative declaration. And that's something that you're not allowed to do in a type 1 action. You can do it in an unlisted action, but you cannot do it in a type 1 action. And the court explained that a conditioned negative declaration is where the proposed mitigation measure was a condition precedent to the issuance of the neg deck. And the court found that that was not the case here, that there were mitigation measures that were discussed and considered, but it was not a condition precedent to the negative declaration being issued. And then the last issue that came up, which is near and dear to Adam's heart, is GML 239, LM and N, which is the requirement that certain projects, if they are within 500 feet of certain boundaries, generally a municipal boundary, county or state park, county or state road, have to be referred to the county planning department for their review and recommendation. This is non-negotiable. And the court made that clear in its decision, that if you do not follow the referral requirements and the decision requirements of GML 239, then your decision is jurisdictionally defective, and it will be deemed null and void if a court finds that you didn't comply with those substantive requirements of GML 239. In this case, after reminding everyone that that's the standard, the court said that the petitioners did, the planning department did actually satisfactorily comply with 239M, because they did refer the application to the county planning department at the outset of the process, but they did not re-refer it, even though there were changes that were subsequently made. And the court said that's okay. If every time something is changed to the plan, you have to keep sending it back and sending it back and sending it back, you're never going to get to the finish line. Basically, it has to be, if it's de minimis, if it doesn't substantially or substantively really change the project, then it's not always necessary. But you should always err on the side of caution when it comes to that, because like I said, if you're ultimately found after the fact to have not complied with GML, it's like statute of limitations. Like there's no room for discretion on the part of the court with that. So that's pretty much it for my secret cases. I'll just briefly address. So the Hart case, I included this. This is incredibly fact-based. It would take 20 minutes just to go through this one. What I thought was important about this case, and I'll just let you guys read it at your leisure, is that it lays out the process of what happens in SECRA if you issue a pause deck, if you issue a positive declaration determining that the project does have the potential for significant adverse environmental impacts. And basically what that is then you have to create a scoping document, which is pretty much like a table of contents or point headings as to what those potential environmental impacts are that are going to have to be addressed in the environmental impact statement. And that provides your outline for the applicant to prepare the draft environmental impact statement, which addresses those issues. Then you hold a public hearing, you receive public comment, and then the final environmental impact statement incorporates all of the responses to all of the comments that were received during the public comment period. And then you have to issue a SECRA finding statement, which pretty much is a culmination of all of the analysis and the board's ultimate determination as to how the project should proceed going forward. And one of the things that was challenged specifically in this case was whether there was an appropriate consideration as to alternatives. That's something that is required to be looked at as part of any EIS. And generally there's a no action alternative, which is basically if you just maintain the status quo. But then the petitioners were saying, well, you should have looked at this use of the property, or you should have looked at it on this property. And the court said, this goes back to the concept of of a reasonable, the standard of reason. And you can't look at everything. And if you have a developer that's saying, I'm going to do multifamily residential, this is what I do, then telling them that they need to look at putting, a daycare center there isn't really reasonable in the context of what the project is in front of you. So you can look at different density, but you have to be reasonable about what you're proposing in terms of the alternatives that you're asking the applicant to look at. And so the court found that that analysis in the EIS in this case was sufficient. And then the last case is Route 17K Real Estate LLC. And I always like to get a segmentation case in there when there's one to talk about. Segmentation is it's generally not condoned under SECRA. It's the concept of breaking down a big project into multiple moving parts so that each segment of its own doesn't appear to rise to the level of requiring as much environmental review as if you were looking at everything cumulatively and together. So that's the concept of segmentation. Again, generally not allowed under the SECRA regs. But in this case, the court found that it was not segmentation because you were looking at the entire project in the context of this 5-story hotel with the circulation and the curb cuts and the parking and deliveries and everything, drainage, everything that goes along with that. And so, putting signage off till the end wasn't really going to change the outcome of that review because looking at signage wasn't going to push this project over the edge, basically, so to speak. And the signage would ultimately have to go through its own independent environmental review at the appropriate time. Okay. So I'm thinking I might go Arlupa first. That way, if we don't get to telecommunications,
that's entirely up to you. That's fine.
So the Extenet case, the wireless telecommunications case, was very, very fact specific. The court was not happy about this case at all. And if I had more time, I wanted to read a little bit of the introductions to the case, but basically the village was pretty indignant about allowing these small cell towers, which were not really going to be in any way impactful, but the village board just absolutely adhered to generalized community opposition. And so the petitioners were able to put in a really strong case. There are certain standards that that the local municipalities are allowed to look at with respect to telecommunications, but there are special rules that apply at the federal level. And so all you can really look at locally is the location and the aesthetics of it. But really whether or not they exist is really beyond the scope. And so here the village board kind of strung the applicant along for a long time. The applicant made a lot of changes trying to appease what the village wanted. Ultimately got to a point they had to enter into tolling agreements because under federal law, you're supposed to comply within, the village is supposed to respond, the municipality is supposed to respond within a certain period of time. That wasn't able to happen. So the plaintiffs agreed to extend the village's time. They did that on several occasions. The village went through a moratorium period where they enacted legislation related to telecommunications. And then after all that, where they thought they were at the finish line, they held a public hearing. The public came out and voiced really baseless reasons for denying this application. It was clear that the public was just against it completely. They were raising health concerns, which under law is not a basis to deny this type of application. But the court said that the denial was a pretense to just accommodate the generalized community opposition. And so there were 3 issues that the plaintiffs challenged the village on. The village had claimed that the plaintiffs hadn't established a coverage gap. The court said, of course they have. And village, you didn't bring up that issue for the entire year and a half that this application was before you. The village just relied upon the map that Verizon had on their website, even though they had been handed maps that had been prepared by experts in the field that clearly delineated that there were gaps in coverage, and these small cells were intended to kind of fill those gaps more so than one of the large cells, which could be, 10 times 15 size the size. That the plaintiffs didn't minimize any aesthetic or financial impact. They went through several iterations of the design. They actually held meetings with the village board where the village board picked out the design on a lot of these. So the court found it to be disingenuous for them to say that this was not, that they didn't minimize the aesthetics given the process that had been gone through and the village's involvement in getting to that point. With respect to financial impact, the court didn't consider that to be meritorious because all that was in the record were basically conclusory letters from realtors saying it would reduce impacts, reduce property values, but not saying how that would happen or why that would happen or how much it would happen. So the court didn't feel like that constituted substantial evidence to justify the denying the application. And the last was the failure to adequately consider alternative options. And the court again rejected that as not being satisfactory based upon the record, where there had been this lengthy review process where the locations had actually been moved many, many times based upon the input of the village itself. So ultimately, the court not only overturned the village board's denial of the area variant, of the approvals for the telecommunication system, but also did not refer it back to the village board for further consideration. The court said, grant it, you're directed to grant it, you have no more discretion, this is out of your hands. So that was how frustrated the court was by that situation. Okay, so I guess our Lupa. So the first case is the YMCA case. And in this case, they had been using their property as a camp since 1921. And the property included camp activities and programming, overnight camps, day camps. But in addition, what the YMCA considered an accessory use was they would let other groups and organizations use their property, which they said was in furtherance of their charitable and religious mission, including hosting weekend retreats for Girl Scouts, religious groups and whatnot. So in 2018, they wanted to get approvals to expand and create this new building that was going to encompass their existing structure and two other structures, two other properties that they had recently purchased. And so they had to get a special permit for that use. So they got the special permit, but the special permit was silent on their prior, what they called accessory use of allowing these other groups to use their property. The municipality looked at it as just, a commercial use to try to make some extra money. But because they had done this land use review, they had to look at the parking from this new expanded development. And there was never any discussion of having these kind of catering or hosting events on the property. And so they didn't make the requirements that they necessarily would have made if this was going to be use of the property. So the town was dug in that, once you got this special permit, your only permitted use is for the camp use with your expanded lot and your expanded structure. And so the YMCA went to court and they claimed our lupa. So the court wasn't really thrilled about having to decide the Article 78 claims, which related to the zoning board ultimately denying their appeal. And so the court said, I'm gonna let you guys figure out if I'm supposed to be doing that. But he did weigh in on our lupa claims, and this was at the motion to dismiss stage. So this was at the beginning of the litigation, where all the court is really looking at is the allegations that have been made in the complaint. So the court said that it was a timely claim because the town had argued that the statute of limitations had run because it was bound by the same 30-day statute of limitations to challenge a zoning board determination. And the court said, no, that is not the case. Our lupa is governed by a 4-year statute of limitations. So that was not an issue. And then with respect to the actual substantive violation, the court did decline to dismiss it, the Arlupa claim at this stage. The court declined to dismiss it and said that at the pleading stage, they had to show that there was a zoning regulation that imposed a substantial burden on the exercise of religion of a person, institution, or assembly. So the court said that at this stage, we think that the YMCA, by alleging that it's, a Christian charitable organization, that its mission is for charitable purposes, charitable Christian purposes, for the community and for health, spirit, mind, and body, all that stuff that they put in their petition, that it was sufficient to withstand a motion to dismiss. But the court did question whether in the end, the YMCA was really going to be able to demonstrate that this alleged use that they were saying was being inhibited, the substantial burden, which was basically, renting out their properties and letting other types of groups use their property, was actually a religious purpose that would be protected by Arlupa. But the court left that question for another day. And then the last two cases are the Congregation Rabbinical College of Tartikow versus Village of Pomona. And this one pops up every once in a while whenever there's a new update. When we were here in March, the court had the Second Circuit Court of Appeals, so the Intermediate Appellate Federal Court, had partially upheld the lower court. So what the Second Circuit said was that the laws that were enacted by the village in 2001 and 2004 with regards to the definitions of an educational institution and provisions related to the use and implementation of dormitories were valid. They were not they could stand, and they did not have to be invalidated. However, there were two subsequent laws in 2007 that did end up getting invalidated. So we still have these two laws about the educational institutions and the relating dormitories on the books. So it looks like the plaintiffs brought a new action challenging those two laws. And the court doesn't really get into much about what the substance of the pleading is, but there was a complaint that was filed, and then the plaintiffs had gone in seeking a preliminary injunction to enjoin the village from enforcing those laws that it was claiming were illegal and unconstitutional. So once the plaintiffs made that motion for preliminary injunction, the village cross-moved to dismiss the complaint. And the court ultimately granted it on procedural grounds, because they said that the plaintiffs did not have standing and that the claims were not ripe for review. And the reason for that was because, as we discussed earlier with standing, you need to be able to show an injury in fact. And in a constitutional claim, that means an invasion of a legally protected interest, and then the existence of a causal connection, and then a likelihood that favorable relief from the court is going to relieve that. But to have a legally protected interest, it has to be real. And right now, the court said the plaintiff doesn't have a real protected interest because it's never made an application for its rabbinical college. And so it has no property interest in an application or in any sort of approval because it hasn't gone there. And the plaintiff's argument is, well, I know what the zoning says, so they're not going to let me do it anyway. But the court's saying is, well, you need to at least make an effort. You have to make one meaningful submitted application to show us that you've done it. And then if the village doesn't respond, then that's a different story. But right now you haven't done that. And that was the same issue with the ripeness. In order for a case to be ripe, meaning it's ready for adjudication, there has to be a final and definitive position taken by the municipality as to the zoning law at issue. And so they run parallel lines. In order to be able to go into court and in order to be able to bring your claim to court, you have to have a final concrete injury that you can present to the court that the court can actually try to fix. Because right now we're not there yet. So in this case, the court said you have to make an application. It has to be a concrete application. It has to show an actual plan of what you want to do on the property. You have to ask for a zone change or a variance or whatever relief you would have available to you under the current zoning, and then see what the village does. Who knows, maybe the village will grant your application and then all of this is moot. But you have to at least try, otherwise we don't really know what we're working with here because we don't even know what the village's position is. And so ultimately, what had actually happened also is that the plaintiffs had made an application for a zone text amendment, but all they said was, please repeal those two sections of the code. There was no actual proposed amendments of language, and it wasn't linked to their proposed use of the property. And that was another thing that the court focused on. So the court ultimately said, do this, put in an application, see what the village does, and then maybe you'll be ready to come back. But the way it stood now, they just weren't there yet. And then I'll just very quickly on the Orthodox Jewish Coalition of Chestnut Ridge versus Village of Chestnut Ridge. I think this is a very important point, and I'm sorry I'm running over. This is the last one, I promise. In this case, there was a complaint filed because there was a zoning code provision on the books that governed places of worship that the plaintiff claimed was a substantial burden on their exercise of religion. So after the complaint was filed, the village amended its law to substantially ease those provisions and actually adopted some of the suggestions, the overall structure and portions of the proposed law that had been suggested by plaintiff itself. So then the village goes to the court and says, well, court, look, we took a good faith step and we did what we were supposed to do. And the court said, you know what, under our LUPA, you're right. There's a safe harbor provision in our LUPA that allows the village or any municipality to avoid, quote, the preemptive force of any provision of our LUPA by changing the policy or practice that results in a substantial burden on the exercise of religion. And this includes retrospective damages. So if the municipality, upon receiving a claim or upon someone saying, you have this on the books and I think it's an our LUPA violation because I think it violates it's a substantial burden on my ability to exercise my religion, and then the municipality makes a good faith effort to ameliorate that issue, then you could end up saving yourself a lot of time and money down the line, because one of the big things you see with our LUPA are these are fees and costs that are associated with it that could get charged back to the municipality. So I thought that was a good point, not one that comes up very often, but one to keep in mind. And I'll stop there.
All right. Well, there's a couple of questions that maybe we can get to quickly. If the building inspector denies the issuance of building permits in an approved planned development district based upon the developer subsequently not adhering to specific requirements such as aesthetics, construction standards, etc., can that developer apply for a variance? If so, would it be an area or use variance?
I mean, if it's related to aesthetics and bulk requirements, that would be an area variance.
Okay. All right. Switching back to the chat. Many people saying thank you, by the way. There was one case, is the development called Lofts on Dietz? I think that was an earlier one. That name doesn't sound familiar. I guess the answer was no. Okay.
Not that I recall.
All right. And if a public hearing is closed, but the applicant and people are texting, thank you. I appreciate the thank yous, but when someone puts a text down there, my screen moves, so I can't read the questions.
Thank you all.
If a public hearing is closed, but the applicant keeps changing the plans in response to public questions and comments, can the public continue to send written comments in response after a hearing is closed?
My practice is I don't like to close the public hearing until the very end to specifically avoid that type of situation. Because if there are changes that are made to the plans that there isn't really an opportunity to weigh in on, that could be a concern. I don't think there's anything to stop someone from submitting their comments, but Technically, the public hearing period is where comments are received. So it really depends upon how stringently the municipality enforces that.
Okay. Well, I think that's the end of our questions. And I just want to say again, thank you very much to Deirdre and Suzanne at the Cornell Cooperative Extension for helping us out. Thank you very much, Christy. These are very, very dense topics, and it's very easy to see how things can go down a rabbit hole very quickly. And to have you come here and shed light on it for us non-lawyers, and to help educate some of the lawyers out there as well. It's a very valuable skill, and we greatly appreciate you sharing that with us.
Thank you, Adam. That's very nice.
All right. So I've given my email a few times. I'll put it in the chat one last time. Carson A at co.rockland.ny.us. If anyone needs a certificate, if anyone wants to get CLE credit, I saw someone asked for the handout. I believe I emailed those out to all the registered people earlier today, but maybe you registered late, maybe you didn't get it. If you want the handout, please email me, or any other questions, just shoot me an email and I will get back to you. And I think that concludes our session. So thank you all very much for participating, and thank you again, Christy.
See you in the spring. Hopefully in person.
Maybe in person, that'd be nice. I'd like that. All right, I'm gonna stop recording here.
Thank you.
All right, so yeah, people are still here, but they're leaving. So thanks very much.
All right, take care. Have a good one.